So we are on section 4 of remedies, and this section, section 3 of remedies. This section deals with jurisdiction, trademarks, service marks. We're going to look at 93A and franchise relationships, so it's a bunch of different things. But first, let me talk a little bit about the trademarks and service marks, which in part open us up to some of the issues in Burger King because they were looking for injunctive relief as well with respect to stop them from using the intellectual property of Burger King. Trademarks and service marks, actually, you can get both on the state and federal level. One affects goods, that would be the trademarks, and the others affect services. And to the extent that your client has unique property or unique services that they would want to be able to protect against others from using similar names or that type of trade where they try to adopt some of the features or designs of your intellectual property to steal your potential customers and goodwill, then you can file for either a trademark or a service mark to try and protect that property. And there's a fair amount of litigation involved with those things that when you do get someone else improperly using your material, whether you've trademarked it or service marked it or not, but having that protection gives you significant advantages when you do, if you do have to litigate those issues as well. But let's start with the notion of jurisdiction, because that's one of the principal issues in the Burger King versus Rudzowitz case. So Burger King sues Rudzowitz down in Florida, and that was a relationship that was supposed to be about a franchise that was located in Michigan that would be selling burgers in Michigan and to likely Michigan residents or some people traveling through Michigan. And Burger King chose to file suit in Florida, where it has its corporate offices. It's a Florida corporation with principal offices in Miami. And they chose to file suit against Burger King down there. And the reason they have filed this suit, Burger King chose to file suit against Rudzowitz and McShara, the operators of the franchise in Michigan. They chose to file suit in Florida and seek an injunction. And we looked at injunctions last time. Injunctions are orders from the court for a party to that action to either stop doing something or to force them to do something. And in here, what Burger King wants them to do, because they see it as a breach of contract, they want them to no longer be allowed to operate the Burger King franchise with all the Burger King's intellectual property and the like. And they want an injunction, and they want an injunction far away from Michigan, because they think they have a significant advantage litigating this matter in Florida, where they are a good corporate citizen, and where they hope that the court can exercise personal jurisdiction over Rudzowitz and McShara operating that franchise in Michigan, but to use it to exercise jurisdiction over them in Florida. Now, the court has narrowed and refined a little bit the whole idea about personal jurisdiction to a greater extent than they had previously. But personal jurisdiction breaks down into two categories. It's the power of the court over the defendant, first of all, and the court obtains it through something the defendant has done in that forum such that it's reasonable to make them come in and defend this action. It's what allows the court to bind the defendant to that judgment, as we call it, an in personam judgment, so that they're responsible for it. But personal jurisdiction breaks down into either what we call general jurisdiction or specific jurisdiction. In general jurisdiction, the most significant change to personal jurisdiction in the last few years has occurred with general jurisdiction. In order to have general jurisdiction, it's not enough anymore to simply have the minimum contacts that we saw in International Shoe and tons of cases following it. But if you're going to say that it is general jurisdiction, then if it's a corporate defendant, the defendant has to be, the new phrase that they use is essentially at home. Okay, so that the defendant has to be essentially at home in that forum in order to have general jurisdiction. For a corporation, it's relatively easy to figure out what that is, and an individual as well. Oftentimes, it's going to be where they're domiciled, where their state of incorporation is, where their principal place of business is. But if you think about that phrase, essentially at home, that's like a place. That's not a bunch of places. And so for a corporation, their corporate headquarters is likely to be that place. For an individual, it's likely to be where their domicile is, where their true fixed and permanent place of residence is, the place they intend to return. It's their home, because that's the language that they're looking at. So it is much harder to now acquire general jurisdiction over a defendant. Let me ask you about that. In this case, is Rudgewitz or McShara essentially at home in Florida? No, right? Clearly that's not, that this is a distant forum for them. If the court, or if the plaintiff were trying to argue today that this was general jurisdiction, it would undoubtedly fail. And so the other means of acquiring personal jurisdiction is what we call specific jurisdiction, right? And specific jurisdiction, as a general matter, we need less to acquire personal jurisdiction when we are arguing its specific jurisdiction. We need fewer minimum contacts in order to establish specific jurisdiction. But the reason we call it specific jurisdiction is because those concepts, those contacts within that jurisdiction ultimately give rise to the cause of action. So the rule is you need less to establish minimum contacts when the cause of action arises from the defendant's contacts within the state. And what this means is that as you move forward, there are far fewer choices where you are able to acquire personal jurisdiction. Because it either has to be by way of general, which is a very limited number of places, maybe one definitely, maybe no more than two in many cases, or specific jurisdiction, and that's where those contacts give rise to the cause of action. So we've got to figure out which we can acquire, because the subject matter jurisdiction is pretty clear. It's filed in federal court. It's based on both diversity jurisdiction. Plaintiff and defendant from two different states claim reasonably likely to exceed 75,000. I also think you have an argument that where you have trademarks and service marks involved, federal trademarks and service marks involved, you have an argument that they're violating federal law by using those in violation of that franchise agreement as well. So you have a complaint in federal court that is then grounded on both violations of federal law, the trademark service mark use, as well as the diversity suit that is grounded in a state contract law claim, because at the end of the day, a franchise agreement really is nothing more than a contract. And I want to have you think about this, and we're going to discuss a little more on Thursday, because you have an article here about franchises, franchise agreements, and there's regulated oftentimes the significant federal statute as well as a state statute that regulates franchise agreements. But a lot of our clients, our potential clients, are going to want to go into business, and for many people, they see it as the easiest way to go into business is to work with a franchise operator. The problem from your perspective in representing them is to the thought about how do I, as best I can, protect them, but also keep the deal together. Because the problem is franchise agreements, as you might expect, are heavily weighted to the franchisor, right? Not the franchisee. It's a standard, relatively standard agreement. The lawyers have written it. The franchisor has a lot more money than the franchisee, and it weights towards one side. You're going to need to read it, obviously, to advise your clients what the problems are. You may have to, likely have to familiarize yourself with federal and state law in the same process to make sure that what you are agreeing to is lawful and there's no protections for you within those statutes. But the problem is, if you think about it, and the last part of this is many franchises are incredibly litigious. We're going to read some Subway cases. Subway is like one of the most litigious franchises you've ever seen in your life. And they structure their arrangements so that it's difficult to access the real money and the real individuals there. But what you have to recognize is that if a lot of businesses fail, your client's business may well fail as well. How do we, at the outset, in representing clients in these types of situations, properly advise them of the risks, but also understand that they would like to get a deal done, but if this deal goes bad, they're going to want to know why you didn't do more to warn them and tell them about it up front. Because a franchise like Burger King is ridiculously expensive. Dunkin' Donuts franchise is ridiculously expensive. None of them are cheap. But if people are putting their whole life savings into it with little protection, it's kind of an interesting problem for you, because how do you properly advise them what they're getting into? Because reasonably, this is an incredibly expensive endeavor. Right? If a franchise agreement is 1.5 inches thick, the federal and state statutes that might be involved may well end up being the same before you're done. That's a lot of reading for you to have to do before you even begin to negotiate anything. The likelihood of negotiating much of anything is pretty low, because the whole beauty for the franchisor is we have uniform agreements, they can be interpreted uniformly, and everyone has to do things the same way. And we're going to see a couple of other cases along the way where it's the franchise relationship falling apart, but I'd like you to think a little harder about that, because how much do I got to get up front then, even to begin to look at this and tell them about their rights? Because if I am telling you, so you've got some exposure here, because when it goes bad, they're going to want to know why you didn't make them more aware of the problems. But even to be able to do a reasonable level of due diligence for you, how much do you need? How much do I have to give you to review a contract that what I'm telling you is the likelihood of you altering anything of significance in there might well be this. Maybe you can get something. Maybe you can get a choice of law provision changed, which, by the way, that's not an insignificant get, but I'm not sure you're going to get that. How much? How much to review all those documents and advise me of the problems and to give me advice I don't want to hear? But I should hear, right? I mean, so what do you figure? 2,500? $5,000? 10? I'm just wondering, I need you to start to think about, so what's that number? Because you've got some risk on the back end of this. You actually have probably some significant risk, right? This turns to crap, like this one did, like the one at the end of this week's lesson does. You should have made them aware of this. And you should also make them aware, I mean, this even beyond the documents. Like if I had a client buying a Subway franchise, knowing the history, and it's relatively cheap to get in. That's why a lot of people do it, but that doesn't mean it's going to be cheap down the road. So, I mean, so you have to do research in that regard too. So, how do I make this all work on a standpoint of dollars and cents. Because what I'm saying is this is not an agreement worth looking at for $1,000. Because you've got liability on the back end here that could break the bank.
Sounds like 25 to 50 hours of just research.
I would think that's easy. Just even not even research as much as, reading an agreement yay thick. Just like you guys, sometimes when you first started law school, you didn't read the case once and know exactly what it said. And then these are not written to be easily understood. These are written to sort of make the company bulletproof. I just want you to think, we'll talk a little more about it on Thursday, but there is a problem as you think about making the transition from law student to lawyer, that people see us as deal breakers. They don't see us lawyers as deal makers, and we're not. Our training isn't in that, right? Our training is to worry and try to provide preventive legal advice. And so, especially in situations where the client really needs it, sometimes they're reluctant to ask because they know you're going to say no. You're going to say this is a bad deal. But maybe you better say it's a bad deal if the likelihood is it looks like there's lots of problems. And sometimes it's just to interpret the agreement. But I mean, we've talked about this before. People click I accept way too easily. I just did a piece with NBC Boston yesterday. They're doing this little demonstration where they're having people sign, just click I accept, and then they tell them what they've accepted without recognizing that they've given up lots of privacy rights, they've agreed to do X, Y, or Z. Well, here, at least you have some ability to tell the client at least how bad it could get. But we're going to see in some of these other cases, the bad is real bad. I mean, here, even in this one, I think is it Rudgewitz? He decides to walk away from this, right? He doesn't even further pursue his appeal. No, Shara didn't further pursue his appeal. The likelihood is because he lost everything already. You can't get blood from a stone, so why am I wasting money to take an appeal? I can't pay the judgment they presently have. I'm probably going bankrupt. Well, you have to start to think about, how do I try to prevent some of that at the outset? And what advice can I give them or can I take steps to try and protect them, recognizing that maybe they won't let me change the franchise agreement, but I better try. And if they say no, then I've got to tell the client he's got some hard choices. I tried to change this, this, and this. And if they say no, then the client has to know what the repercussions of that are. And sometimes maybe you can do some things to protect them. But again, this is not an inexpensive endeavor. So we'll talk a little more about it as we look at some of the other cases. But especially if you're thinking about doing some business arrangements and representing clients in contract situations and the like, there's a tension there between them wanting to get the deal done and having an agreement that I was going to say you're comfortable with, but you may never be fully comfortable with, but that at least you can apprise your clients of that some of the risks are minimized, but they're never removed. And if the deal goes bad, they're going to come back to you to wonder why some of this stuff wasn't pointed out. And some of the biggest one is relatively easy now, because that choice of law, choice of forum, that can be negotiated. But if it can't, that's a pretty significant one that you can have a hard conversation about. The fact is, it makes a huge difference if we can sue here as opposed to having to go to California or Florida or Texas. It makes a huge difference to know, okay, it's mass law, I know mass law, I can tell you what remedies we may have here. But if if it's Oklahoma or even California, well, I don't practice there. We have one now, we're just wrapping up, it's Connecticut. Connecticut does things, their procedure is very different. The law is basically the same, but their procedure in the civil courts is very, very different. So everything we do down there, we got to look up. And then you got to, how come we can't do this? And how come we can't do that? And so it adds a layer to it, even though the courthouse is only 2 hours away from here. California, I can tell you from having practiced it, does things dramatically different. And plus the distance, you'd need counsel there. You'd have to have local counsel. And that makes it much harder then, and a much more serious discussion about, is this issue really worth litigating? So all of those things go into these agreements like this, because when we think about this one here, Rudowitz and McShire are at a significant disadvantage if they have to go to Florida to litigate this suit. And that's what they worry about, because Burger King has filed suit against them. They're saying it's a breach of contract. A lot of times in these franchise situations like this, you also end up having a countersuit. The countersuit is, fraud and, failure to disclose, because when they were wooing them, they were telling them of all the riches they could make as a Burger King franchise, and none of that has come to fruition. So oftentimes you have dueling lawsuits. And so Burger King wants it in their home court. They file suit, and they want to stop them from using their intellectual property to preserve the Burger King image, and to terminate the franchise relationship because of the breach of contract. And so I guess the first part of it is should these folks have, do you think these folks should have reasonably expected that they were going, if there was any problem with respect to this franchise agreement, that they could reasonably anticipate that they would be hailed down into Florida based on a franchise that was going to operate in Michigan? Is this reasonable or unreasonable for them to have to go down there? So what do you think?
Reasonable.
Why do you think it's reasonable?
They agreed to the terms and conditions when they
Well,
signed.
when you say they agreed to the terms and conditions, what terms and conditions are you referring to?
Well, the long arm statute, that they would be under that choice of law.
Okay, so there is a choice of law provision in here, but it's not a choice of forum, right?
Right.
And we all understand the difference. Choice of forum makes at least part of the problem really easy. It says, listen, if there's any dispute, we're going to Florida. But this is not a choice of forum clause, and that, to some extent, that might have highlighted to Rudowitz and McShire an unsatisfactory location. So what they did instead is they said, okay, we'll use Florida law. And a lot of times I could live with that far more easily than the forum if the forum isn't to my liking. Because I can say, okay, worst case, I can still file suit here if I'm fast enough. And we end up having to use Florida law. The problem is when you're agreeing to a provision like that, I think to some extent you folks would have to make yourself aware of what the terms of Florida law are then, no? And one of the things we're losing when we do that is Mass has 93A, which we're going to look at tonight, or start to look at, which is a really good provision that protects both consumers and businesses from unfair competition. And that's a big thing to give up, and it should be something you're aware of when you are. And that's one of the things I always try to check when we're agreeing to some other law is, do they have, in essence, an equivalent to that type of protection? Because a 93A action will give you double or treble damages plus attorney's fees. So it's a significant remedy that both consumers and businesses can use. And if we're giving up that right, that's something that the client should know. But it's even more important, in my opinion, to know, listen, we're going to have to go to Florida if there's any problem. And what that means is we're going to need Florida counsel, because I'm not authorized to practice there, and the likelihood is with such a distance, we would need local counsel anyway. So we'll get local counsel, and we'll move my admission pro hoc vice for the case. But all of that means cha-ching. Even Connecticut charged me $1,000 for a pro hoc vice admission. I know, $1,000. And that's not chargeable to the client, as I could reason that through, because it's my expense to be able to practice there, but that's for that case. And so that's relatively modest compared to, okay, I need local counsel, and so now we need another set of lawyers on the case. It gets expensive. At any rate, So here, they've got a choice of law provision. The choice of law provision says that regardless of where the suit is filed, we agree that Florida law will control. And Rutgers and McShire are saying, okay, I get that. We can use Florida law wherever we are, but that doesn't mean that we could have reasonably anticipated being hailed into court in Florida. And so I guess that's the question that we looked at. Did we do this case when you guys were first in Civ Pro? Okay, so you remember it, because what's nice about the case is it gives you sort of the highlights of all of the cases on 472, 473, sort of the history of all of these cases, and some great language about minimum contacts, foreseeability, systematic and continuous activity, and all of that. And the question becomes, and you look at that language, that regardless of all of the fancy things we used to look at, now it comes down to really the couple questions. They're not essentially at home in Florida, as you've already said. So there is no basis for what we would call general jurisdiction. So the only thing you're left with, if personal jurisdiction can be acquired in Florida, is specific jurisdiction. Does their contacts in Florida, potentially, are those contacts sufficient that they give rise to this cause of action? So what were they doing between Michigan and Florida, or what did they specifically do in Florida that one could argue is a basis for specific jurisdiction in this case?
They signed the contract in Florida.
They didn't or did?
They did. I think that's the only thing they did.
When you said they signed the contract in Florida, did they signed it in Michigan and sent it to Florida, or they physically signed it in Florida? Because I would think these days you'd have a hard time showing. I just sent, well, you tell me where it is. I sent off 2 agreements today. We executed 2 here yesterday. They're executing 2 in New York tomorrow, and then we're going to exchange them. So they're going to get mine, they'll have their 2, and they'll sign those, and then we'll have them, those 2, and we'll sign here. So there'll be 4 originals. Where were they signed?
Right.
No, really, right? Because, I mean, if you think about it, that's when you say where the contract was signed. So did they actually go to Florida to sign, or that one of these situations where they exchanged agreements and the like, where did they negotiate the terms of the contract? Florida or Michigan? Where they make the call, or where they make the call to? The point is, with a lot of these, we can argue both things. Where did they buy the equipment for Burger King? For their Burger King in Michigan. They were told they had to buy it out of Florida, right? Where were they trained? One of them was trained at Burger King University in Florida. The equipment was bought in Florida. The goods were shipped from Florida. They shipped their payments down to Florida. Is that enough to argue then that that the cause of action arises from their contacts within the state of Florida, or is this a situation where Burger King really today would likely have to go to Michigan because, well, clearly one could more easily argue that the cause of action arises from the contacts where the franchise is physically located, where the burgers were going to be sold and all of that. That's a relatively easy one to argue. Can you win an argument that Florida is also a place that we could argue that they should have known that their contacts there were in fact creating that meaningful and purposeful activity such that those contacts would give rise to this cause of action? Because that's what you're left with these days. And the reason I'm pointing it out, at least in part to you, is to think about it from a little different standpoint. Because some of these cases, like especially the Keaton versus Hustler magazine case, which was filed up here in Florida, that there'd be no basis for jurisdiction in New Hampshire anymore under Keaton versus Hustler. You cannot say that Keaton's cause of action arises from Hustler's contacts in New Hampshire. And it's certainly not a basis for general jurisdiction over Hustler magazine. Those concepts have been restricted and refined in the last few years to a much greater extent. What does that mean for these guys? Can you argue, because the only thing you have to argue is we can acquire specific jurisdiction in Florida because their contacts in Florida give rise to the cause of action. You comfortable with that argument?
Well, when he underwent training in Florida, he created the significant contacts, ties, and relations in that state because he spent significant time there getting trained. And, also all the product comes from Florida, the machinery comes from Florida, everything comes from where they're essentially at home in Florida.
Well, no. Burger King is essentially,
Right,
but they're the plaintiff, so we don't care. It's where the defendant has those contacts. And all of those things you first said, that is in fact the argument as to what they did there. I'm uncomfortable though because a lot of those contacts, and even the choice of law provision occurs subsequent to the contract. Right, I mean, because in part the court argues here as well that choice of law provision that you wanted in the contract, that's there. That's a significant contact that helps to establish a basis for jurisdiction. But it is the contract itself is what we're making and what ultimately this suit is about. I'm not so sure you can use all of the things I'm not sure you should appropriately be using all the things that occur subsequent to that entering that agreement to say, well, that gives rise to the breach, or gives rise to the cause of action, because the cause of action really is the breach of contract. The attending Burger King University, buying the equipment, all of that, to me, occurs subsequent to what is the origin of the suit. And so I'm a little worried that's not necessarily a fair way to look at it. I never really liked that the choice of law should be considered a significant contact for them, because they accepted it, but that's likely pretty boilerplate. But the fact is that at the end of the day, the court earlier was relatively comfortable that there was a sufficient basis for jurisdiction. I don't know whether that's true with respect to these folks with the more restrictive view of how to acquire personal jurisdiction. I think that you could have, I think you could have solved this a couple different ways, and many contracts do now. A lot of contracts that businesses and individuals enter into, it's not just a choice of law, it's a choice of forum clause as well. So a lot of these, you waive any ability to contest personal jurisdiction, just like you can waive any of your constitutional rights regularly, and you do it by way of the contract. It takes that off the table. We know where we're going to go, and we know what law we're going to use if there's any problems whatsoever, and the courts will readily enforce those provisions, especially between two business people. But we've seen in Carnival Cruise Lines, they'll also require a consumer and a business to equally be bound by those provisions. And so what they've done here is decide, at least at this point in time, that they feel comfortable enough that there was a basis for jurisdiction. I don't know whether the court would rule the same way, and that's why I wanted to start out and point it out to you, is that we've got a lot of great cases about all the contacts and purposefully availing themselves and all the rest, and it's still good language and it's still stuff we would look at, but the fact that the defendant could argue to me to a greater extent that this does not, this cause of action doesn't arise from their contacts within the forum, and therefore it would be unfair to require them to go down to Florida. You know, the other part of this here, and what we see sometimes in order to avoid a piece of business litigation like this, is they should have struck first. You know, could Rudowitz and McShire have sued them in Michigan? Sure. Fraud, you know, the fraud in the inducement that they told us the money would be so much better than it is. They made a lot of misstatements and promises that they are same type of thing. It's a breach of contract and it's a fraud claim. And to the extent that they were first, there's no doubt that they've got jurisdiction over Burger King. Again, won't be general, but you'd argue it's specific jurisdiction. And under the circumstances, they're a plaintiff instead of a defendant. And in the real world, we start to think like that. You know, we've got a dispute. We know one of us, we know we're going to court. Rather be a plaintiff than a defendant. If I've got a good faith argument and they filed a counterclaim here, so they obviously feel that they were wronged as well, then it becomes a rush to the courthouse. Whichever one gets there first may have a significant tactical advantage over the other, and that may well matter in the real world as to who got to court first, who's the plaintiff, who's the defendant, as to how that case is perceived. That's something that we think about with respect to representing clients when we've got this type of significant business dispute that needs that type of attention. And you know, the other part of it to think about is that there's businesses do business all over now. So there's a lot of times where it's a relatively easy argument to make that this cause of action arises from our activities within the state. This is what we did, and that ultimately gives rise to where we're at now. Let me make one point about, Jeeves had mentioned the long arm statute. Again, from a real world situation. What long arm statutes allow us to do is serve absent defendants. Defendants not physically present within our borders. And so we still make an analysis, as always, about are we going to be able to have a basis for jurisdiction, generally specific or general. And if it's general, then there should be a resident agent, so it's not a problem, meaning there's someone that you can serve within those borders if, in fact, they are essentially at home. If it's specific jurisdiction, then you may have an absent defendant. Anytime you have an absent defendant, you first have to decide, can we make the argument about specific jurisdiction? Does the cause of action arise from their contacts within the state? But you then have another analysis when they're not here, because you know Rule 4 is going to require you to provide service of process to that defendant. And we've talked about it in the abstract as notice reasonably calculated under the circumstances to apprise them as to what's going on. But in the real world, what it means is when you enter your complaint, you pay an extra $1, it might even be $5 now. They'll give you a summons from the clerk's office. You will complete that summons and provide it to a marshal or sheriff or even by certified mail with a copy of the complaint, and you will get that notice to the defendant, and that's when the clock starts running for them to file some type of response. Rule 4 in federal court, Rule 4 in state in Massachusetts as well, dictates the manner of service, okay, how the defendant has to be served. Most defendants don't need to be served in hand, but they do need notice that is provided to them consistent with Rule 4. When I say consistent with Rule 4, what that means is that, and we're going to look at this on Thursday, but Rule 4 will say, depending on the type of entity it is, certain types of service and the type of matter, there's a method of service that must be made in order to comply with Rule 4. For instance, most services, I said, don't need to be in hand, but divorces, the service required generally is in hand. They want to know the person actually got it in their mitt. But most times that's not what's required in many other types of actions. But Rule 4 is going to dictate the manner of that service. Rule 4 oftentimes will say, both federal and state will also say, and you can use the state's long arm statute to serve process to absent defendants. So in essence, they incorporate that state long arm statute into Rule 4. But the long arm statute doesn't authorize service in every case. And long arm statutes differ from state to state to state. So you've got to look to make sure that when you're thinking about entering a suit, that not only do we think we have jurisdiction, but we can obtain a lawful means of providing them that required notice. Because if you enter your complaint and you don't serve the defendant timely, then that complaint will be dismissed. If you enter the complaint and serve the defendant, but it's improper, then they may well move to dismiss and be successful at it. So you want to know not only is this the right court, but that we can make sure we bring them into this court consistent with Rule 4 so that they can't move to dismiss. And so at some point, on absent defendants not within the geographical borders of that court, you end up having to use a long arm statute to provide them that notice, and then the service has to be made consistent with the long arm statute. And one of the ways our long arm statute authorized service is by certified mail, return receipt requested. So if I send it to Jeeves and Jeeves signs the green card and I get it back, that's good service. When I get the green card back, then I can make that return of service on the summons, file it with the court, and your 21 days starts ticking. If I give it to a marshal or a constable or a sheriff for service, they would, on the original summons, return it to me with their notation as to the means of service. I would then take that summons and file it with the court so the time can start to run. So, and service of process isn't a huge expense, but it is an additional expense. Depends on the method of service, but really we're talking $50, $100. We're not talking break the bank money. But if you don't serve the case, if you don't serve it properly, at some point it will be dismissed. But so long arm statutes help to allow us to provide that notice consistent with Rule 4. Rule 4 dictates the means of service. Okay?
Now, what if that green card comes back in the long arm statute unsigned?
Yeah, now you've got no service.
Even if you made all the necessary...
Yeah, now you got to figure out what's the next step, and that happens a lot. I semi-kid around. I mean, who goes sign for those things? It's never good news, right? No, seriously. Car insurance, yeah, right? Insurance is being canceled. Something else bad has happened. It's not good news, and most people know that, especially and a lot of times they'll show you who it's from, and you say, oh, nothing good's coming from a lawyer. And so a lot of people don't. Some people will actually reject it. It'll say rejected. Still doesn't mean you have service because they haven't got it. And so then I've got to work a little harder at it. There are people though that even with the sheriff will reject the service. They won't. I had a lawyer on Tremont Street in Boston let it fall to the ground. He asked his name. He said yes. He goes to give it to him. He said, "Here you go, sir." And he moves his head, let the papers fall. They both walk their respectively away. And he said, "I served him." And the lawyer, of course, says, "No, he never served me." And he knew what it was about. And he left it there. So sometimes people will deliberately evade service of process and make it more difficult. At some point, you can ask the court for alternative means, or you can even ask if you've tried a million ways that you've constructively served them, or if they're really impossible to find, you can do a service by publication. But that's you're going to have to show you've tried everything else possible before that, because we know it's a pretty ineffective means of providing notice. But
Publication is very expensive.
Yeah, it is. That's the other thing. It's not. By the way, though, if I got a sheriff or a marshal sitting outside his house for 3 days, that's not going to be cheap either. And sometimes, if I've got to get in-hand service, he says, "Listen, I've been down there a couple times. He's never home. What do you want me to do?" And well, I gotta get him served. Maybe I'll send. If you're going to do that, then maybe I'll send him down to your work if I know where you work. I mean, you're going to make me work. I've got to get him served, but that's going to cost me money potentially. They're not going down for nothing, right? Sooner or later, someone's got to pay for it. But service by publication, for as ineffective as it is the most expensive form of publication, most expensive form of service. It's ridiculous because no one sees them anyway.
So what if he's refused and just as like he opens his vehicle, you throw it inside?
When, so what? So he does so I see him?
I see him opening his vehicle, I just throw it inside.
Oh, yeah, I don't know. I don't think in-hand service truly means I've got to hit your fingers. It means I've got to provide it to you. And if that's close enough for me, I think most sheriffs and marshals, constables will consider that in-hand service. I provided it to him. If he lets it fall, that's one thing. But what about, I thought you were going with the house. So you see, he opens the window, he looks out and says, no, not today. And if it's got to be in hand, you got a problem. You know, and that's the other thing, by the way. The person serving process oftentimes doesn't know what they look like. So now I've got to get that information to provide it to them so that they know who it is they're looking for. It's in most cases, it's not a problem, but there are some cases where that people are absolutely going to hide until they no longer can hide. And it becomes problematic if you need an in-hand service. But as I said to you, luckily, most cases don't. Most cases, if it's an individual, if I leave it at your house and I send you a notice by first-class mail, that's likely good enough. Very few cases actually need to hit your fingers. And if it's a business, a lot of times we can serve the managing agent of the business, or we can serve a corporation, we could serve your resident agent. That most corporations doing business in a state have to appoint a resident agent for service of process. So it's only the rare case where individuals are deliberately trying to avoid getting that paper in their hand, and you know, then you're going to have to be a little more clever about trying to get them to service.
Do you think one day we're going to reach a digital service of process, meaning that you'd send somebody an email, they'd open up an email, boom, you've been served?
Yeah, I do. I think now a lot of the class actions have been more digital notice and the like. There's no reason why not in many cases. Now some, again, like the divorce, like some specialized cases where we need to know for child support and for property division and for everything else that person has the notice. But especially if the course of conduct was back and forth by email and the like, I'm not so sure it doesn't make sense that we could save some of the money and the time doing it that way. Most of our papers in federal court now are all filed electronically, and then service is made electronically as well. So, I mean, the federal courts have moved to that, except for the service of process, the regular service of process. And so I wouldn't see it as a big leap for them. Our state courts are still way, way behind with respect to electronic filings. I mean, it's like night and day. You could go onto the federal court database and you could find papers filed all over the country. Now there's a class action lawsuit about that as well. PACER, which is how you get access to those papers. And someone has now said they're way overcharging for access to the paperwork that's on file in the federal court. And they do. They charge a lot of money. Well beyond what they need to make that work. And so I forget which, but I think there's two major public interest organizations that are suing on a class action basis for it, because they said they're generating fees well in excess of what it needs to provide that really First Amendment information to the public. And so even though federal courts are way ahead, they've got other problems with respect to accessing that information online. But the availability of the information is incredible. The speed and all from the federal courts. State courts, it's still a real mess.
Now, does it have to be a constable? Can it be an agent of the lawyer that serves?
It's got to be a disinterested person for the most part. So if they're my agent, I would not consider them disinterested. And so usually it's going to be a marshal, a sheriff, a constable, or a disinterested person if authorized by the court. But to me, your agent isn't disinterested, so that creates that problem. So a lot of times this service isn't an issue. We just send it out, and they serve it, and they make their money, and we move forward. But there are some times where there's some people and some companies that are going to make it difficult. I had one, I filed suit against the federal government 2 years ago. They argued in their, one of the things they argued in the motion to dismiss was they weren't served properly, because we served the U.S. attorney here, and the statute does say that not only do you have to serve the local U.S. attorney, but you have to serve the U.S. the Attorney General in D.C. as well. So they moved to dismiss, well, they had moved to dismiss it for other reasons, but so they added that in. So it's simple fix, so then we just serve them in D.C. as well, and that's off the table. But it's silly, because to me, moving to dismiss for lack of proper service, when you've got service, some judges are going to say, come on, let's just get to it, where others are going to take a stricter view of it. I would have thought our government would just simply do the right thing and move on. Another mistake by me. It's even worse what they did in the case, what they had done to create this cause of action that they then argued wasn't illegal or improper at all, which was grossly illegal and improper. But that's a story for another day. So, at any rate, under Burger King versus Rudgewitz, they were able to bring them to Florida, and ultimately the injunction, and we talked about the 5-part test and the injunction last time, ultimately the court was able to shut the franchise down. But what's interesting about it, and again, just from I'd like to point out some of the practical parts of it here. It said McShara stopped, didn't bother with the appeal, he was out. At some point, as a practical matter, we have conversations with our clients about does it make sense to continue to fight this battle? If McShara has no money left, in essence that he's what we call judgment proof, then it doesn't make a difference what this court does. He'll wait till it's all over, and at some point he's likely going to go bankrupt. Or maybe he doesn't go bankrupt, but he still has no money and no assets and he has nothing to worry about. At some point they might take that judgment and just throw it away, because a worthless judgment is a worthless judgment. Sometimes if they're going to pursue it, then at some point he has to decide to go bankrupt and be done with it. But as a practical matter, clients run out of funds. And that's from the standpoint of what we've got to be aware of, is both from the plaintiff and the defendant, that it doesn't make sense always to chase someone who's got nothing. And if you're doing it on a contingent basis, it means you get a third of nothing. Even if you're doing it on an hourly basis, to me that's something you need to have a discussion with your client with, because the client shouldn't be throwing good money after bad either. Okay, I'm getting paid, but you will never get paid on this. Do you really want to continue to run up the bill and pay these expenses when the likelihood is that they're judgment proof and there'll be no money? And for McShara, he made that decision and simply walked away. And I think I see more and more businesses actually making business decisions about the cost of litigation. And that's something that, historically, that wasn't as significant of an issue. I think these days, for you guys, as you go out and practice, it'll be even more so, cost-effective justice. Because businesses don't have the tens of thousands of dollars, individuals certainly don't, to throw at us to defend what they may or may not feel is right or wrong. But at the end of the day, running up tens or hundreds of thousands of dollars on a piece of litigation that you can't promise results isn't always the best move in the world. Let's talk a little bit about Anthony's Pier 4, because this is one of my favorite cases in remedies. And so Anthony's Pier 4 and HBC Associates, two monsters in the real estate, ultimately in real estate development and the like. But what this case starts about is what we call, and it's a very important statute in Massachusetts, Mass General Law, Chapter 93A. Okay, Mass General Law, Chapter 93A is a statute passed by the legislature that protects people and businesses from unfair business practices. So it protects both consumers and businesses from what the court determines would be unfair business practices. If it's a consumer who brings the action against a business, then the consumer has to make a demand letter first, explaining what the unfair practices are and saying what their damages are, and giving the defendant 30 days to make an offer of settlement. If the defendant doesn't within that time period make a reasonable offer of settlement, and the plaintiff is ultimately successful in litigation, the plaintiff is entitled to not only their actual damages, but those damages should be doubled or trebled, 2 or 3 times what their actual damages are, plus they're entitled to collect all their attorney's fees that they was spent on the case. And that's a big game changer. So that's one thing to start to think about. Is anytime we have a legally viable theory that there's a 93A claim, we plead it. Because it changes the dynamic, right? It allows me potentially double or treble damages, plus all the attorney's fees. Now that means, I have to go to judgment, I have to go to trial, I have to be successful. But in the event you put me through all that, then I know that there's a big pot of gold at the end of the day. And that's huge, and it changes the dynamic about engaging in settlement discussions and everything else. So 93A becomes a really important weapon in your arsenal. If it's a business that is suing for 93A violations, another business, because it regulates business practices. So it's not, consumer can't sue a consumer, but a business can sue a business, consumer can sue a business. If it's a business practice, you don't even need to start with the demand letter. So you can actually just go right to sue. We'll look at that down the road a little bit, but even though you can, it's always good to start with the demand letter, to put the other side on notice what you're complaining about, what it is you feel they've done wrong, and what you think your damages are. They may start a dialogue. Maybe we don't even need to file suit. I think that's unlikely, but at least it gives you a starting point as to where you're at and what it is you want. And I think a lot of times judges want to know, what's your demand? What are you looking for, and what do you want to get? And that's something you need to think about too before you ever go filing suit. What is it you really want here that you would accept? But in a business v. business situation, as a general matter, the type of practice that's an unfair business practice has to be more significant, more deceitful, more dishonest than if it's practiced against a commercial innocent. In essence, what we expect is that if you're going to engage with consumers, there's a greater level of ethics that would be used, as opposed to businesses dealing with one another where they compete. And when you compete, one person wins and one person loses. And so businesses the practice has to be more deceitful, more unfair in order for business versus business to be successful. But, so Anthony's Pier 4 is the suit that we're looking at, and there's a huge 93A claim in here. I hope you read the case, and look, I want you to look at it carefully, because there's a lot going on, there's a lot of things I want to talk about between today and next time. But let me ask you a couple questions. Let's set the table a little better. So there were 2 agreements between Anthony's Pier 4 and HBC Associates for development of the Fan Pier project. Now this is back in 1991, before anyone called it Seaport, and no one really ever lived there back then. And so it was a lot of parking lots and a lot of other shenanigans, but it wasn't a very desirable place to live. And so they were fighting over the development rights for this project. And so, let's see, I'm trying to remember which one actually, okay. Yeah, here it is. Okay, in January '88, Anthony sued HBC, and on the same day, HBC brought suit against Anthony. So in my opinion, it is my opinion, but I think it bears out by the facts. Anthony knew HBC was going to sue. So what he did is he jumped the gun and sued first. Better to be a plaintiff than a defendant. Okay? And so HBC is the Pritzker family from Chicago, massive amounts of money. Anthony is Anthony Athanas, who operated Pier 4 for many years, had politicians in his right and left pockets, and was a significant political and financial force in Boston. And this was supposed to be about the development rights. And so there was an agreement between them. It was a jury waive trial, which simply means the parties are agreeing that they don't want a jury. By the way, a 93A action, this is a breach of contract, as always, oftentimes coupled with a 93A. But in a 93A action, there is no right to a jury trial. It's a creature of statute. There's no requirement that the legislature do that, and they didn't. So 93A doesn't have a right to a jury trial. It would be a judge-made remedy decision at any rate. And so we've got questions about the covenant of good faith and fair dealing and all the rest of it. And ultimately, the cases go to trial. Okay. I'm just going to set the table. So Anthony looked at this contract and looked at what the development would bring to him, and said that he's not making enough money on this deal. That if he stuck with this deal back in 1991, 30 years ago, that his family would get a lousy $750,000 a year, and that's peanuts to him, and he wants to break the agreement because it's not enough money. So he's a little greedy. And you are the lawyer, and Anthony gives you that agreement, and he says to you, find me a way out. Right? That's just find me a way out. He wants you to be the deal breaker, because you're the lawyers. People do that type of thing. And like with any, especially a big agreement like this, there's got to be some things that the other side hasn't done that they should have done. So I guess that's my first question. If Anthony puts a big pile of money on the table for you and pushes it your way and says, break this agreement, you in or out? And are you pushing that money back to the table and saying, Anthony, this would be morally wrong? Or we all got student loans to pay. This is a big, and seriously, this is a big climb. This guy, if you win this case, you beat the Pritzker family of Chicago. For Anthony Athanas, you own the city. So you pushing the money back because this would be the wrong thing, or you counting your money on the way to the bank? That's my question. Are any of you saying, no, that would be morally wrong, Anthony, to find an out just for that?
Well, what makes it wrong? We're looking at a contract to see if there are any issues with it.
Well, is it issues with it? He's actually, and that's a nice way for you to put it, to help your conscience, but he's actually giving it to you and saying, find a way I can break it, right? That's what he's asked you. So does that bother you at all, or is that what we do? We protect our client's interest. We don't really care about the other person and what that does on that side. That's who we are. I'm asking. I mean, you're getting paid to do it. Pritzker family has plenty of lawyers to do the same thing.
Screw the Pritzker family.
Because you're going to represent Anthony.
Yeah.
Okay, so that's it? We're all in on that? None of us? I mean, it's just a contract. Because, by the way, over the years I've found, your civil, your criminal cases, you all know who's supposed to be the bad guy there. Civil cases, it's not always as clear. Sometimes it's not even as clear till you get halfway in. You say, oh, I don't think I got the good guy here. But so I'm wondering that. I mean, because I think sometimes you think, oh, these don't have problems like that. Oh, yes, they do. And that's what I'm asking. So screw the Pritzkers. I've got Anthony, that's my client, I'm going all in. All I gotta do is find something that they breached here, and we're gonna send them off a letter saying, I'm sorry, we're out. Well, we're out unless you can come up with to $2 million a year. But that's our job. We are the warriors for our clients, and that's what we're paid to do. So everyone's in on this? No one's pushing the money back across the table, saying, Anthony, that would be wrong. No. I'm asking.
I think the moral compass is much smaller in this case because we're talking about two conglomerates.
Oh, because you don't care about rich people at all.
I really don't.
No, but they both can take a hit, I guess.
That's how I
So
see it.
no one's gonna sleep on the street tonight, no matter what happens here. Who the hell cares? We're all gonna make some money before this is done. No, is that, but then that means we have problems too. So that some clients, we're gonna care a little more about what we're leaving behind, and others, like these people, if they've got enough money that they can fight about a lousy $750,000 a year, I'm not gonna lose sleep much over this. But okay, then I'm asking, is that right though? They want to fight about it, I'm their man, because I'm getting paid, they're getting paid, it's all about lots of money. I hear you, I'm just
Gotta
asking,
keep the lights on.
gotta keep the lights on. Bill's gotta be paid in
Gotta
here,
get paid.
Someone's gonna do it.
I'm not putting some orphan out in the street or anything.
No,
Here,
it's not two indigent parties here.
no, these are incredibly powerful and well-off companies and individuals.
To answer your question, yeah, there is moral problems with this. I mean, a guy's coming to you saying, yeah, I'm in a contract that's legally enforceable, but I want a way out. Breach it. Find a way for me to legally breach it. Yeah, there's a problem with that. But morally, like I said, my compass is much smaller in this case because, I mean, they're two conglomerates.
So it doesn't affect you morally. You know, it's not really right, but I don't really care. It's not. No one's gonna die over this. No one's gonna. I can sleep on my bed of money tonight pretty good. So no one's going to give Anthony a little conversation about, well, this could go bad, or this could be wrong, and you don't know how the court could see this, or
I'm sure you're gonna have that conversation with him, but.
so you're going to have a conversation with him as you take his money. You know, okay, this, just so you know, this might not work out the way you think, 'cause that's the way that goes.
That's the move.
But does that worry you, that shouldn't we have had a conversation with him that not only is it morally wrong, the court might not see this as you and I see this, is that it's a breach, and therefore you are well within your rights to just get out, right? I mean, because if he could do this to them, what's he going to do to you?
Right.
No?
Very possible.
Very possible, right? Because he's willing to roll in the mud with moneyed and powerful interests. Who the hell are we when things go bad? Not that I'd turn down the money or the desire to get involved in a case like this. I mean, this is a big case. This is gonna, you win this case, you don't have to worry about a lot of clients for the rest of your life. They're gonna be finding you, and he's gonna be sending you people. Really. Financial and money and powerful people. I'm in. And none of us are worried about what happens when it doesn't quite go Anthony's way. Because I want you to read it, and make sure you read this case, because there's so much going on. There's a lot of stuff here I want to talk about. But I'm going to tell you, it doesn't all go Anthony's way. So maybe we should have had a little more come to Jesus meeting at the outset. As long as he's in for it, at least I've warned him. But if again, that's kind of delicate too. I want him too much of an extent. He's leaving my office and taking his pile of money with him. So I just look at it carefully, because there's a lot going on, and I want to talk about it in depth. It talks about a couple things I want to point out. It talks about expectancy and reliance damages, which I would expect you could all define for me since you had contracts already. But I also would expect that no two definitions in this room will be the same. And shouldn't they be? Shouldn't you all have a working definition of that? Because, by the way, that's the other thing why I want, it's not just the definition, I want you to look at it here. It's tens of millions of dollars different, depending on whether he's entitled to expectancy or reliance damages. So I want you to look at that as a practical matter as to how that works. And I also want you to look at note 15 here and ask you about this. I'm going to leave you with this as we go. Okay, note 15 says that on the same day you filed the suit for Anthony, and you all filed the suit for Anthony. It says on that very same day, you also took this property and placed it into a trust with Anthony's kids' names on it, in essence making it harder for the Pritzker family to get the land. So you in for that too? That's what it says. You see vote no 15? So I mean, what the hell, right? In for penny, in for pound? Zach says, yeah. If I'm in, I'm in. No? I want you to look at that and think about that. And I want to ask you, because this note doesn't need to be here. I think the court has put that there to prejudice us, and maybe it prejudiced them against Anthony when they said, oh, okay, he knew what he was doing was wrong. And again, you helped him do it. Doesn't make you look that good, does it? But you don't give a shit because you got lots of money from this case. No? Right? That's what I'm hearing. So just think about it. We'll talk about it on Thursday. Because it's a great case. There's so many levels.